Okay, y'all, I got on my lawyer hat. That means we're going to talk about lawyer things. Today, we're going to talk about what happened with the College Sports Commission and these 18 Nebraska athletes. So, for context, in total, the College Sports Commission, also just called the CSC, the acronym, has cleared almost 27,000 deals worth $242 million since July of 2025. Okay? They have denied 1,153 deals worth $56 million, including these deals with these 18 Nebraska athletes. So, of course, when folks get denied, they get mad. So, in one of the first test cases, the 18 Nebraska athletes decided to file a claim against the College Sports Commission for failure to approve their NIL deals that they signed with Playfly Sports, worth about $7.5 million. Under the terms of the relationship with the College Sports Commission, any and all claims must be subject to arbitration. So they arbitrated. Now, the CSC itself ruled that Playfly Sports was an associated entity under the House settlement and the deals were not proper. And so they denied them. Okay. Now, an associated entity, just so we can get our minds right around what's what here, is an entity or individual that promotes or supports a particular NCAA program. Now, that aspect was intended to cover collectives and boosters, okay, as an associated entity. But the definition is broader according to the CSC in the way that they read the House settlement, because under the CSC's guidance, it also includes an entity that has been directed to assist in the recruiting or retention of an athlete or otherwise assisted in the retention or recruitment of an athlete. Okay? So the CSC has very narrow authority with respect to associated entities and is limited in their ability to enforce, okay, to requiring that the NIL payment be for a valid business reason. Valid business purpose. That's the term of art, valid business purpose. Okay. So if there's an associated entity that is either looks and feels like a collective or booster, or has been directed to assist in recruit or retention of an athlete, okay, any payments that those entities make must be for a valid business purpose, okay, and at rates and terms commensurate with the compensation paid to similarly situated individuals or with comparable NIL value. So that was a whole mouthful there. Okay. So essentially, we need to be similar and you need to pay us similarly. That's part of the test. Okay. So Playfly Sports was the entity that was supporting these Nebraska football program with respect to, the Nebraska athletics program with respect to these 18 athletes. And so the arbitrator found that Playfly was, in fact, an associated entity. And so on the first test about an individual or entity that promotes or supports a particular NCAA program, they don't really pass that test. It's not them. But if you go deeper and you say an entity that has been directed to assist in recruit or retention of an athlete, then Playfly Sports seems to fall within that category, at least according to the arbitrator. So the arbitrator found that Playfly was an associated entity. It's the first thing they found. The second thing they found was that the deals didn't satisfy the valid business purpose requirement. Okay. Third, they found that the deals with Playfly were warehousing the rights, the NIL rights. So what does that mean? So the arbitrator said that Playfly was guaranteeing payments in exchange for as yet unspecified services that it hopes to sell in the future, okay, to an unidentified person at an unidentified date to promote an unidentified good or service. And so that is the definition of warehousing. So the notion is we got a whole bunch of money, okay, and we're going to pay you for things that we have not yet specified. But it's going to come up, and when it comes up, we're going to pay you. And the arbitrator's like, no, you can't do that, okay? Because it must be a valid business purpose, and it must be activated at the time that the relationship is entered into. And so you got to know you have to do these 5 things in order to get this money from this organization or this entity. And this notion of at some point in time, we'll tell you who it is. We don't know when, we don't know where, we don't know who. The arbitrator was not persuaded by that. So they're like, nope. Right now, Playfly Sports is an associated entity, and so they have to go through this more rigorous screening to determine whether those deals are valid. So the Nebraska athletes did not get paid under this current rubric. Okay? Now, what happens next? The athletes can just resubmit the claims, resubmit the payments, okay, the request to comply with the rules. Now, because the arbitrator has said what you can't do with respect to warehousing, the Nebraska athletes will not have their deals structured in that way with Playfly. Okay. So, and the arbitrator said, look, you can resubmit, and CSC has said we will prioritize your payments if you resubmit them in the proper form. So ultimately, these athletes will not be harmed, delayed, but not denied. Okay. Now, it's also possible that the Nebraska Attorney General could sue the CSC under Nebraska law because they have this rule that prohibits any organization from penalizing an athlete for being paid for NIL. Okay, so I'm gonna leave that alone. That's a very specific rule that is specifically aimed at the NCAA and athletes getting money under NIL and the CSC. It's very narrow law. Okay, that says you can't enforce your rules to the extent there's going to be a penalty to our athletes in our state. Okay, now the third thing that's going to happen next is that there's a different set of plaintiffs. So outside of this arbitration, the House plaintiffs have already set in motion. They have filed a motion to have entities like Playfly Sports, who are multimedia rights companies, to have them exempted from the definition of an associated entity. And that hearing, I believe, is later on this month in May 2026. So that's what happens next. Those are the 3 things that could happen next. Now, what are the takeaways that we should take from this? First, the warehousing thing is a problem. But you know what? It's not unusual. And so now everyone is on notice that you can't structure your deal that way. And I know that folks just got buckets of money that they're putting into these entities and saying, hey, I need you to figure out how to distribute this money in a way that is consistent with the requirements of the settlement. But yeah, you figured it out. I've given you the money. You sort it out. Okay, so I know that happens. But now folks know, at least until you get some different ruling about whether this kind of structure with these multimedia rights companies is an affiliated entity, you can't do that. Okay. But additionally, people should just write better contracts. And maybe because I've been writing contracts and very sophisticated contracts for so long, when I see things that are just raggedy contracts, I just get irritated. Just burns my soul. Okay. But the arbitrator has now given these contract drafters a roadmap to what they can and cannot say in these agreements to get them to pass muster. So the first test case, CSC ended up holding firm and they won. The arbitrator ruled in their favor. But now the arbitrator has given some guidance on the way folks can get around some of these issues. The Nebraska athletes will not be harmed. They can refile their NIL structure, their NIL deals in ways that conform with the rules, and they will ultimately get paid. So anyway, that's what happened. And we'll see what happens with this court hearing to see if these multimedia rights companies end up having this designation taken off of them that they're affiliated entities. As always, let me know what you think.